देखिए कन्वेंशन को
করবো একটা এটা কার কে দিয়ে গেল
দিয়ে দিচ্ছি।
in a compelling circumstance I have to mention can you take this matter I moved this matter day before yesterday but my prayer was that only to clean the bushes. My lord has recorded that for entering into the premises and clean the bushes they has given a totally change to the trial court's order.
Without entering, you can't.
I am there
No.
if
Your
my
side-
lord
If you want any modification, please ask your.
this is not for modification this is
no,
probably
no,
my lord has recorded my submission. I have said I want to first paragraph 7th line from top I want to clean up that's all and I will file the application with the court below. Whatever the order is there today subsisting before the court below that will prevail. Otherwise it can be said the modification of the order of the court below.
That you are in position.
In such circumstances, question of permitting the petitioner for
To
cleaning.
Cleaning only cleaning will do. If I am not in possession if I am not in possession no question this is my submission probably my lord has recorded my submission probably if that be so kindly delete that part and say that only for cleaning.
That can be considered. See, because we have signed and uploaded.
No
draft.
problem.
If there is a typographical mistake to be mentioned,
No.
we can do.
Your lordship's court judgment says if my contents is recorded wrongly, I have to go to that court and make this
Yes,
clear.
yes. You file.
That's why I have come.
No. Let the counsel on record file an application. We list it on.
As your lordship. Otherwise, it will be modification of the trial court's order.
We'll clarify.
Grateful.
May I have a lordship, please, my lord? An accommodation I seek. Due to my advancing stage, it feels I should discharge my responsibilities as early as possible. Two matters are there. One is appearing in the list for item number 51, group matter in the monthly list. And another is Saturday club as early as possible. Your lordship can be accommodated.
Okay. You please give the number. We'll do it.
I'll give it.
My lord, this is for correction.
What is the mistake?
Correction, my lord, review. Your lordship directed Panchayat to, but your lordship wrongly revenue officer. But it will be Panchayat. Order.
You will list it for to be mentioned.
Your lordship, I'm mentioning this matter being section number 15 of 23 for inclusion in the list for admission. I have submitted
You give
the
the
mentions. Great.
My lord, may I be permitted to mention one matter, my lord? This matter, your lordship has passed an order on 5th March. And in fact, this matter, I am the respondent number 6. And I am not present at that time when the matter has been called on. But what I am to say,
Your lordship, may I? Your lordship, this writ appeal has been effectively dismissed by your lordship. However, your lordship, in para 4, it is gone as disposed of. And your lordship, in paragraph 3, your lordship has given them liberty to make an application. Your lordship kindly gives us liberty to file our opposition and
obviously
kindly observe. Your lordship, your lordship knows how it happens before the trial court. Kindly gives us.
No. If an application is filed, obviously
Your lordship, this may be treated as your lordship that the application will be made and it will be allowed. So your lordship would kindly clarify that the respondents can file their opposition and the application, if made, will be decided on its own merits.
This is appellate.
That's all.
But who?
That matter.
No. Yes,
The
same.
Basu, yes,
Mr.
mentioned.
Basu mentioned today.
Your lordship.
So let it come on Monday.
Under the your lordship, today, your lordship, if any time. Your lordship.
We have asked them, they want some clarification.
Grateful, your lordship.
Yes.
Just a daily matter, item number 1.
My lord, service is not complete. If your lordship kindly grant us an opportunity, my lord. Otherwise,
This is actually settled. I have, even as a single judge, I have done this in my parent high court.
Yes, my lord, over here the tribunal.
And tribunal referred to a larger bench decision. What
Yes.
happened to the larger bench decision?
My lord, that was challenged by the revenue before the Mumbai Nagpur bench. That matter is pending, my lord. I have the number, my lord. I have the instruction I have from the department, my lord. And we have referred several judgment of the Honorable Supreme Court, Madras High Court, other high courts, as well as the tribunal's order. That was not considered simply following the larger bench decision, my lord. The learned tribunal has passed
All
this
right,
order.
list after services service
Grateful,
of
my lord,
notice is
grateful.
completed. Then you bring all the
Judgment, we will make a
But we have made a
compilation, my lord.
compilation.
Grateful, my lord. We will make a compilation. এই নামটা কি?
I appear on behalf of the appellant, your lordship. I'll be seeking a day's accommodation, my lord.
there is an application for condemnation of
Delay.
delay.
No, it's an
44
appeal,
days
but my lord,
It's a combined application for condemnation of delay as well as for stay.
So we can condone the delay today.
My
my lordship.
44 days.
How many days? 44 days.
44 days.
Effective.
All right, delay condone.
Let the matter come up next week.
It
or
will come next week.
Grateful.
The union of it. Me and Sharajit.
82 days.
My lord,
In their
I'll-
application, they say
yes,
it's
my lord,
44.
I'll explain, my lord, because in the meantime, there's a period of from roughly 19th of April till 25th of June. We had filed a recalling application before the learned single judge. We were proceeding on the basis that the learned single judge may recall that order because it was not essentially passed
Doesn't
on
matter,
merits.
but,
And the department, I think, has not taken that period into consideration. If my case is that if that can be,
and what
Uh,
happened to your writ petition?
my lord, the writ petition was dismissed by the learned single judge on the point that we had not disclosed a certain material fact that we had gone and filed an SLP before the Supreme Court, challenging an order of the learned single judge in a prior writ petition. So that was the point, my lord, on the basis of which the learned single judge had dismissed this particular writ petition. My lord will kindly give me some time. I'm being led by my counsel from Bombay. He'll appear next week virtually and apprise your lordship on the merits of the matter.
Asking for the condemnation of delay too.
Now, what was that appeal? What was the appeal before the Honorable Supreme Court?
My lord, that is not, I do not have the records with me. I'm very sorry, my lord.
So is it fatal to the?
If I may apprise your lordship with the facts of the case. My lord,
My lord,
linguistic-
it's my appeal. Let me first place my facts of the case, then my learned friend.
We are trying to ask a friend, is it so fatal?
My lord, yes, my lord, it is. Because
That's the only thing, my lord. Let my counsel, my lord, appear on the next
All
page.
right, delay condone.
or may it retain its position, lordship.
No, it will come as under the caption admission.
For admission.
82. We will take it as 82 days.
Number 3.
This is my appeal. The only point is, Mala, the ITAT never, Swativaja judgment, not considered. That is the only point.
My lord, the SSC is opted for Vivad se Vishwas.
Pardon?
SSC is opted for Vivad se Vishwas.
Now.
So we'll dispose of the appeal.
My lord.
This appeal has been filed by the revenue under section 260 in the preamble you take, sir. Huh?
Yes, that is.
The and advocate appearing for the respondent assessee submitted that the assessee has opted for settlement under the direct tax Vivad se Vishwas scheme 2024. And an application has been filed on 18th January 2025.
My lord.
The application has been accepted.
My lord, I have not received Form 2 as yet.
All right. In the light of the same, this appeal stands disposed of. as no further orders are required in the matter, and the substantial questions of law suggested are left open. Suppose your application is rejected,
My lord,
what to do?
then my lord, I have to come back before my lord for
So in the event, the application filed by the assessee under the scheme is not accepted, then liberty is granted to the either side to seek for restoration of this appeal to be heard and decided on merits.
I'm grateful, my lord.
Item number 4.
But I'm appealing for the applicant. No, we have served them. They have received this. There's no delay in the matter. My lord.
No delay. Oh,
Yes,
sir,
sir.
very surprising, Mr. Doria.
I think, my lord, there's no delay. My lord, my lord, this is regarding section 68, my lord. My lord, if your lordship will kindly see the questions are there. My lord, if your lordship will kindly come to the assessment order first, my lord, page 9, my lord. Capital share premium. It is found that the record the SSC received raised the share capital a huge share premium during the year, but the SSC failed to incorporate the high value of the premium and the credit worthiness of the received the share premium. Though there was a business activity, but the book value of EPS could not justify the high value of premium of unquoted shares. The replies of section 133(6) sent by the investors were almost identical in style and submitted almost the same point of time. Some of the investors submitted reply without receiving. I'm just reading the letter. Even the addresses of the registered dealers or some of the companies sent with the common directors. All this proves the convenience of SSC with the investor company. The SSC failed to cooperate with the creditworthiness of the investors despite reasonable opportunity. Hence, just because the share applicants with a huge and unjustified share premium was received from corporate entities, though banking channel does not justify the creditworthiness of shareholders. But this is the that's why it was the CIT appeal also was of the same view. But the tribunal, my lord, lordship will kindly see CIT's observation. That is CIT.
Tribunal says
Yes.
that they have furnished evidence
Yes.
to prove the identity and creditworthiness.
Yes.
What about genuineness?
But that has not been proved, my lord. But before the assessing officer, I don't think this should be reported. Nothing has been quoted by the assessing officer. Lordship will kindly have a look at the assessment order, my lord, that they have filed everything that has not been there, subject to correction, my lord. Genuineness also was not proved, my lord.
You come to page 28, para 5. That's
28,
where
yes, ma'am.
discussion starts.
Yes, in the tribunal's order, yes, ma'am. 28, paragraph 5, yes. That is the discussion. We have considered tribal submission and gone through the. We find what is the contention. We have also the assessment order is short. We also note that the assessment order is short and cryptic order. There is even no mention of the names of the share subscribers in the assessment order. What to say the details and the evidences furnished by the assessor. Though the assessing officer has observed the assessment order, that the addresses of the registered officers there were some companies where some common directors full and the further all the directors. What is not facts? The assessee with the investor company. However, the observation of the assessing officer in view of the goes in favor of the assessee rather than against. Why this is it is generally observed that the company is always interested in its group companies and always prefer to make investments in the group companies as there is a security of the investments being common directors. The group company not only are known to each other, but also they are fully aware of the financial strength and the future projections and progress channel of such company. The name of the directors in the investor companies were also furnished. The name of the directors of the investor company were also furnished, but not from the assessment or.
They are common set of directors.
Yes.
And
Yes.
that's why if you come to page 29, that first paragraph, last 5 or 7 lines.
Assessing officer observed that in the assessment.
No, before that, the name of the directors of the investor company were also furnished with the AO, from which the AO had made observation the investor companies and the ASSI company have common directors. This fact on the file also proves that the ASSI duly established the identity of the share subscribers. AO neither discussed about nor pointed out any defect, discrepancy or infirmity. Even during appellate proceedings, ASSI has furnished all documents to prove. CITA did not refer to any of the documents furnished, nor did not point out. upheld the also in a mechanical manner would reveal that it's a copy paste a standard order without referring to facts. Even some of the observations are contrary to the observations made by the AO. Has observed also so and so so and so.
But the DR, next paragraph, the DR's observation, will kindly have a look. Though before the learned DR has filed a written submission, the DR has also taken itself analysis. That's not pretty. Next page, the crux of the submission of the DR is that the net profit of the share subscriber companies was low. He has further pointed out that the considerable amount of income from the sources has been neutralized by the amount of total expenses. There was less cash in hand, that the investor companies has received premium on sale of shares and had paid premium in purchase of the shares of the to the assessee, that the assessee as well as investor companies were involved in purchase and sale of shares of a lesser known companies, and that shall be that that all the investor companies were generally group companies managed controlled by the common directors. Neither the assessee nor the investor companies were blue chip companies, that the investments were not secured, and there was also rotational movement of funds, and that there was no merge.
No, I think it's correct order. Swati Bajaj will not apply.
But if genuineness, creditworthiness, genuineness, how identity and creditworthiness,
if it is a common set of directors, then some inquiry need to have been done.
My lord.
Assessing officer just noted this.
Yes, it's cryptic order, my lord. Yes, he has not. It's not. There's no elaborate submission.
And tax effect also will not be much because.
Yes, the tax effect is 21 lakhs and not.
Then.
But that is there, my lord. Tax effect is, my lord, 29 lakhs 8,000, my lord. That is there in paragraph 9 of the.
Please come.
But I'm late by Mr. Omnan Rai.
Sir, please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the act is directed against the order dated July 15, 2024 passed by the Income Tax Appellate Tribunal A Bench Calcutta within bracket tribunal in ITA number 718/KOL/2019 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page numbers 4, A and B. We have heard Mr. Om Narayan Light, senior advocate, assisted by Mr. Prithu Doria, learned standing counsel, senior standing counsel for the appellant revenue. Though notice has been served on the respondent, none appears for the respondent. The issue which falls for consideration is whether the learned tribunal was justified in setting aside the order passed by the Commission of Income Tax within bracket appeals 15 Kolkata within bracket CITA dated 10th October 2019, by which the CITA affirmed the order passed by the assessing officer dated 30th March 2015 under section 143 within bracket 3 of the Act. The learned tribunal has elaborately considered the factual position and faulted the manner in which the assessment was completed by observing that it is a cryptic order without discussing any of the facts, nor the submissions made by the assessee, nor the documents produced by the assessee to prove the three factors, namely credit to the identity, genuineness of the transaction, and creditworthiness of the subscribers. The learned tribunal also found that though such the documents were once again produced by the CITA, the same were not referred to, nor any defect or discrepancy was pointed out on the said documents. Apart from that, the learned tribunal has also pointed out that there is factual mistakes committed by the CITA while passing the order, which are contrary to the finding, contrary to the conclusion arrived at by the assessing officer. The learned tribunal took note of the decision of the Honorable Supreme Court. in PCIT versus NRA Iron and Steel Limited. What is the citation, Doria? And noted the principles which were summed up in the said decision when a case is considered under section 68 of the Act. After noting the said decision, the learned tribunal examined the factual position and found that the initial burden cast upon the assessee has been discharged in as much as the assessee had produced documents to prove the identity of the subscribers, the genuineness of the transaction, and the creditworthiness of the subscribers. If such was the factual position, then in terms of the order passed by the Honorable Supreme Court, the burden shifts on the department to prove the contrary. For doing so, it is necessary that the assessing officer should embark upon an fact-finding exercise, which unfortunately the assessing officer did not do in the instant case. The revenue cannot deny the fact that the order of assessment, as observed by the learned tribunal, is a cryptic order. Thus, we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal fails.
Get from it.
My lord, I'm requesting for a nod today, my lord.
Why? It is department's appeal.
Yes, ma'am.
My lord, we have just got the
But who's appearing, sir?
My lord, my senior Mr. Shraff is appearing here somehow.
My lord, we have not.
Sir, once again. Sir, there is a delay of 57 days. No, there is no separate application, nor there is a specific prayer in the statement.
My lord, then we need to file a fresh application. I mean, we will file an application for condonation of delay. My lord, according to our understanding, there was no delay. My learned friend has filed it. Endorsement, they can in. But a 56 days delay. My lord, give us 2 weeks time, my lord, we shall.
How did
বলছে ডিলে আছে
দিতে হবে?
কবে রিসিভ করেছেন?
6 months time. Time.
হয় আর ভুল আছে।
না, order dated 6 আছে। Department has received only 21/8. তাহলে 21/8 হলে 6 months. Then it is within time. How it is delayed?
The tribunal on merits held against the assessee, stating that it will fall under business auxiliary service.
But on the question of limitation.
MSST, sir, why they should...
there is a case of today I did not bring the judgments. In case of BSNL also the Supreme Court held that not only the nature of the activity, because in our extended period of limitation, the adjudicating authority has held that it is a unique method adopted by the MSTC to evade the taxes. That is at page 54.
You show the relevant allegation in the show cause notice.
Yes,
for the extended period of, how you have invoked the extended period.
Yes, my lord. Extended period has been...
Show cause notice, page 28. Page 31, reasons for invoking extended period. The said assessee failed to comply with the requirements of statute. They have not paid appropriate service tax as payable by them, so and so. Contravene so and so. Neither the assessee paid the so and so. Affected relevant duty.
It was a case of fraudulent and irregular non-payment of service.
Here using the word fraud, it will not become fraudulent.
Lordship, they have used it.
Then what was their explanation for?
Well, it explain in the at page 53, the adjudication the adjudicating authority deals with the same from paragraph 13.1, page 53. It is their case that being a government PSU, suppression cannot be alleged. To that extent, the adjudicating authority in 13.2 has held that in deciding the issue, let us go into the facts of the case and the reasons forwarded by the department for invoking the extended period. It is a fact that the noticee is registered with the department under the category of business auxiliary service. It is alleged in the show cause notice that neither did the SSC pay appropriate service tax, nor they have disclosed the details to the department. It is also alleged that despite being aware of their tax liability, they kept the department in dark against the service provided, on which tax was not discharged for a long time and willfully evaded payment of tax. It is undeniable that the noticee was aware of the tax liability for the simple reason they had already registered themselves with the department as BAS. They devised a unique method to evade tax by taking means of camouflaging the income received towards service rendered by creating a fictitious head in the nomenclature markup margin to put a well on the taxable income received by them. They took plea that markup margin is a surplus on sale and not service charge. In the liberal era of tax administration where self-assessment is in force in the matter of service tax, great faith has been reposed on the SSC, and it is the sole responsibility of the SSC to properly assess tax and pay the same to the government exchequer. Since there is no reflection of the consideration received by them in the statutory ST returns for the impugned period, it can be concluded that there was conscious and deliberate withholding of information to keep the department in dark about their activities. Though the company is a PSU, the fact should not influence or prejudice the adjudicating authority, as the law laid down by the Parliament has to be applied uniformly into all entities, whether they are in the public sector or in the private sector. It is a fact that had no audit being conducted, non-payment of tax of such magnitude could have remained undetected, and as a consequence, government would have been deprived of a precious revenue. Thus, the extended period of limitation has been rightly imposed.
What do you say, Mr. Sharaf?
My lord, I'm not in Calcutta. We just got the brief yesterday. I don't have the brief also, my lord. If your lordship can just make it not today, I will respond, my lord, on the next date.
Then we'll have it after 2 weeks. In the meantime, let them file a Section 5 application.
Yes, my lord.
We have heard Bhaskar Prasad Banerjee, so and so, Mr. Vinay Sharaf. There is a delay of 57 days in filing the appeal. However, no application has been filed for condemnation of delay. The honored advocate for the appellant prays for 2 weeks' time to file such application. Prayer granted. Adjourned.
Grateful.
Number 6.
Well, may I file the affidavit of service? My lord, here is a case of section 68, addition under section 68. My lord, the 131 notice was issued, but the SSC and the directors did not appear. My lord, kindly see, my lord, from the assessment order, page 13. The summons under section 131 was served on the director of the SSC company to appear personally, requesting to produce and justify the following points. SSC's case that some document has been filed. However, the SSC company filed written submission against the summons under section 131 with photo identity of director's investment, but no reason of a non-appearance of the director is furnished. Thereafter, page 14, middle portion. Since there was no compliance from the SSC, the identity, genuineness, or creditworthiness of share applicant company have not been established because the primary issue regarding with the diligence done, the steps taken for the protection of the fund, and most importantly, the reason of investment in the company with a track record, and that too with a huge premium, is not clarified. Primarily due to non-compliance on the part of the SSC, a detailed shareholder was not available, and hence the identity of shareholder is questionable. If the identity of the creditors had not been established, consequently the question of establishment of genuineness transaction, creditworthiness of the creditor did not and could not arise. But thereafter, next page, in the instance case, someone was issued 1.3 million. Summons were issued as his company has not been complied with due to non-appearance of director and subscriber company. The verification of the share capital introduced during the previous year could not be made for the part of the assessee company, and identity, genuineness, and credibility of share application have not been made. Now, before the tribunal, the tribunal was of the view that the document has been filed by the assessee. Now, your lordship kindly see, CIT, from the assessment order, it is apparent that the assessing officer only gone with the issue that the directors has not been appeared, and he had section 68. That will be the case of the assessee. Now, your lordship kindly see the CIT appeals order. He has taken everything. Your lordship kindly see from page 34. Page 34, from page 34 to page 40, these are the entities, and CIT appeal categorically stated what is the case made out. You lordship kindly see page 34. Now, may I read out? The Lucky Prime Financial Consultant Private Limited. As per company information given by the appellant, the said company is in existence since 2011. Now the assessment year is 2012-2013. It is registered address in such and such. Is its authorized share capital is 5 lakh and paid up capital is such and such. The subscriber company has collected share premium of rupees 1.76 crores on share capital of rupees 4 lakhs and odd, which appears to be an abnormal, and subscriber company has no track record and activity whatsoever, or these are no projection of any activity is surplus in only 53,000. The subscriber company had received rupees 5 lakh and odd, and which profit of rupees 44,000 is earned. The fund collected are entirely investment in loan and advances of rupees 1.6 crores, and there is a bank balance of rupees 88 lakhs. The subscriber came to have investment rupees 2 lakhs and odd as share application money and premium.
Mr. Surana, there is no discussion about the correctness of the CIT appeals order in the tribunal.
My lord will kindly see.
My lord he has gone share subscriber by each company. The CIT has discussed.
Page 40, you should kindly see page 40. For my satisfaction, page 40.
Page
40 of the CIT. Now, his observation. Your lordship kindly see. Brilliant work done by the CIT appeals, subject to lordship correction. The subscriber company were observed to be having a number of common features. The registered address of some companies are common. Moreover, the director of the company also are found to be belonging to the group person. The account, I am led by Mr. Dutt. The accounts of the companies are audited by some groups of the auditors. There are no activities apparent from profit and loss account provided except the receipt of interest. All the common companies have only furniture and computers as assets. There is no evidence on office premises of the schedule of the assets.
No vehicle or office?
No vehicles. All the companies subscribing to the shares sold by the appellant are companies with barely any track record and accumulated profits. In none of the cases, source of investment in the shares of appellant company is out of the profit earned or share capital. In all assets, in all cases, the shares are purchased from the share premium collected by the subscriber company. In all cases, the share premium is appropriately larger than the share value as at par.
But this probably identity has been proved, but that is also very doubtful. But so far as creditworthiness and genuineness, it has not been established.
My lord,
only
will kindly come to
my
page
lord,
13 of the assessment order, my lord.
last paragraph. Last paragraph. From the aforesaid observation, it is clear that the appellant companies does not result in the discharge of the owners of such and such. The first two entities are the individuals, they are promoters of the appellant company. The promoters of the appellant company did not pay the premium, my lord.
They
Yes.
didn't pay premium.
Yes, you lordship kindly see. Promoter of the appellant company, they did not pay premium. But the others pay premium or crores of rupees. You lordship kindly see.
No, paid premium only to the extent of 10,000 rupees. That
No,
is
no,
what the commissioner appeals gave it back to them. So that is by the reduction of your lordship will see at page 41, the last paragraph, the addition of 10,798 rupees is without any basis and hence deleted.
Now, your lordship kindly see page 54 of the tribunal's order. The promoter of the company. Serial number 2223, Aditya Mundra, Sonali Mundra. The share premium table is 1434. Share premium table, their share premium is nil. If the promoter of the company, they did not pay the share premium, the others is paying the share premium for the crores of rupees.
Third column is share premium.
Yes, the third column is share premium, that is nil.
My lord,
my last submission, last submission. This is your lordship order. I take a copy. This is the Balgopal merchants case, same principle, same thing. Your lordship decided. Paragraph 23. The first issue is whether the summons issued under section 131 were served or received by the assessee. In this case, assessee said, we have not received the summons, it has been received after the assessment order. In this case, summons has been served. There is no denial. The assessee has taken a definite stand on the said issue as before the CIT appeal. Assessee contended that the notice were received after receiving the assessment order. The said abutment is absolutely vague since the assessee has not given the date on which they have received notice nor the date they received the assessment order dated at such and such. In the supplementary affidavit in the paragraph number 4, assessee would state that the notice dated March 3, 2015 issued under section 131 of the Income Tax Act never served on the assessee company and such compliance could not be made on the same. That it appears to be contrary stand taken by the assessee to that of the stand taken by the CIT appeal. The largest thereafter, my lord, next paragraph, my lord, last line, thereafter we have to necessarily hold that there is a non-compliance of summons issued under section 131 of the Act. My lord, paragraph number 25, third line. The CIT on examination of the fact, same case, my lord, before my lord, in this case also, my lord, same fact. The CIT on examination of the fact found that the assessee company has no track record or asset before base or demanding astronomical high premium as per share of such and such, defying all commercial and financial prudence and logic. Here also, the tribunal, learned tribunal, did not make any comment upon the CIT appeals order. Any finding has not been discussed by the learned tribunal. Learned tribunal goes with the only order of the assessing officer. On the point that some document has been filed, the assessing officer did not make inquiry. It is not that.
Now all of them are paid share premium at the rate of about 4,900 rupees.
Yes, because share value is 10. Your lordship kindly see the column 1, 500 shares into 10, share capital 5,000.
5,000. Share premium to
Share
45,000.
Yes. Thereafter, in next year, next page, 10,000 share value, 4,90,000, and here 32,000 for third serial number 8, 32,000 share value, premium is
1 crore 96 lakhs.
And my lord, no discussion in the my lord, in the order of the my lord, learned tribunal.
Yes, sir.
My lord will kindly come to page 13 of the assessment order. Second para.
13.
Page 13, my lord. That is assessment order, page
Yes.
1. The business of the SSC is real estate. During the previous year, the SSC company has received large share application money along with premium. Kindly see notices under section 133 was issued and reply against the said notices were received in this office. So notices were issued to all the shareholders and all of them have replied along with the requisitions, whatever it is. Now, what my learned friend says, however, the SSC company filed written submissions against the summons under section 131. To whom it has been issued, my lord? Summons have been issued to directors of my company, not to the shareholders' companies. So I am not supposed to bring all those evidences because what evidences has been required are of those shareholder companies. And those shareholder companies have already filed 130, everything in reply to 136. There is no dispute about that.
But then Supreme Court says source of source also has to be gone into.
My lord, that is what they have given the source of source. Kindly come to my lord.
BST. In the matter of CIT versus BST, you also be held that in the BST matter, source of source.
Source has to be shown.
My lord, kindly come to the 136 notices issued. I have not received those copies. But here, there the ITO wanted the source of source also, and all of them supplied the source of source. Kindly see.
But then it's beyond commercial prudence, no, where there is no asset base for the company. The company doesn't even have vehicles, computers. They don't have any business, and they're all working in the same address, audited by the same auditor. Everything
Same
is there.
person.
And you are paying 10,000 rupees premium, and the other fellow is paying 1 crore 20 lakh premium.
My lord, the auditor is not same in few cases only.
Maybe.
So that may be.
Maybe.
That is possible, my lord.
That is not a very big point. 5 companies can engage the same senior counsel. There's no issue.
If the group companies are there, my lord, 5 companies, same auditor may be there. But then the AO has not brought on record anything. What the learned CITPL, my lord, has done is that he has taken out something from the balance sheet itself.
No.
He has not made any inquiry, my lord.
You cannot deny the fact that CITA has done a very good exercise.
Yes. My lord, he has simply picked up from the documents on the record given to the ITO, and he has analyzed the balance sheets only.
21 companies he has discussed. 21 companies.
My lord will kindly see the order of the tribunal.
Before the tribunal, you should have demonstrated that whatever was the factual finding in respect of those 21 investor companies or share subscribers was factually incorrect. That the assessee did not do.
My lord, kindly see page 46 to 49 of the paper book. There the tribunal has given the synopsis of the paper book. All the companies are active still today. All the companies are active.
Maybe they are all paper companies. But then,
my lord, there is no allegation of paper company by the ITO.
No, but maybe a company which is having some business. But then, what we are to require under, examine under 68 is relevant to us. Not your company is a paper company or a shell company, etc. Admittedly, those share subscribers are registered companies. And the authorized share capital is only 5 lakhs. Share premium is 1.76 crores in one case. Another case, 31 lakhs is the share capital. 14.85 crores is the premium.
My lord, in those cases have been completed by the ITO assessing them. They have not disputed that. So how can this ITO dispute that this is not genuine? How can this CIT dispute that this is not genuine? Because all are active companies, all are assessed to tax, all have filed their income tax returns in all the cases assessments have been completed, my lord.
Earning 5,000 and 2,000, they are giving premium of 5 lakhs, 10 lakhs. Their assets is earning 5,000 in the year. And no discussion in the ITAT tribunal order about the factual aspect of the CIT appeals.
My lord,
there is nothing in the order.
Mr. Surana says, page 56, para 17.
Page 56, para 17. Well, this is Milord.
Maybe that the tribunal has said, but all share applicants having substantial creditworthiness is.
But that is not.
My lord, my
that is not
my humble
proved.
submission is.
But that is not at all proved.
It is
My lord, my humble submission is that
No, we are not
inquiry,
saying, Milord, the company
nobody
has been
made the
stuck.
inquiry at all.
Start up company has been, Milord, not
Neither
doing
the
business,
AO
but
has
doing
called
business
for
of
the
the
directors, nor the CHAPL has called for the directors.
5,000 in year doing business, only Milord, chair table and computers.
It is only whatever is taken out is only from papers, my lord.
And Milord, whatever he has filed before the tribunal is a case, the paper books have been filed before the tribunal. Nothing has been filed by the before the assessing officer, before the CIT appeal. Something has been filed by the tribunal, and tribunal passes the order without looking. The AO and
Along
the
the finding is
did
that
not get
everything
the
is filed before
opportunity
the
to control the document.
my lord. Finding is that
Everything is
filed before the
filed by your paper book before the tribunal.
And my lord,
filed by the revenue and
even otherwise, 3-1 Act, this doesn't fall because there is no allegation of the AO or CITPL. There is accommodation entry or organized tax crime.
All right, we'll
That is also not there, sir.
hard case on facts. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 13/8/2024 passed by the Income Tax Appellate Tribunal B bench Calcutta within bracket tribunal in ITA number 807/KOL/2024 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Page number 6, 7, 8 and 9. 1 to 8, sir. All 8 questions. We have heard Mrs. Arya Dutt, also Soman Bhattacharya, Sam Surana. The issue which calls for consideration is whether the learned tribunal was justified in setting aside the order passed by the Commissioner of Income Tax Appeals, National Case dated 27/3/2024, by which the appellate authority confirmed the order passed by the assessing officer dated 23/3/2015 by holding that there is an unexplained cash credit as contemplated under section 68 to the tune of to the tune of rupees 2,84,15,960. The learned tribunal has referred to the details of the share subscribers / companies in paragraph 11 of the impugned order. It is seen that impugned order, which contains a tabulated format giving the names of the shareholders, number of equity shares, share capital, share premium, share application money, and net worth. In the said tabulated format, the directors of the respondent SSC, the names of the directors of the respondent SSC also find place in serial number 22 and 23, and surprisingly, those two directors have not paid any share premium. Furthermore, on a perusal of the said tabulated statement, it is seen that the share premium paid by all the share subscribing companies / entities are substantial in nature. Therefore, we need to consider as to whether the 3 factors which have to be established, namely the creditworthiness of the investors, the creditworthiness of the investors, the genuineness of the transaction, and the identity has been established. It may be true that the identity of the share subscriber companies have been established, in as much as it has been shown that they are registered companies. Yet, to escape from the rigor of Section 68 of the Act, the assessee is also bound to prove the creditworthiness of the parties and also the genuineness of the transaction. Thus, we are required to see as to whether this exercise had been done by the assessee. Admittedly, the assessee, before the assessing officer, the assessee was called upon. No, sorry, sir. The assessing officer issued notices under section 133 within brackets 6 and served on the for which reply has been stated to have been received. Summons was issued under section 131 on the directors of the assessee company to appear personally and to produce various documents. However, the assessee filed written submissions in response to the summons with photo identity of the directors of the investee companies, but no reason was assigned as to why the directors did not appear in response to the summons. The assessing officer took up the case for discussion, took note of section 68 of the Act, and held that there was non-compliance from the assessee, the identity, genuineness and creditworthiness of the share applicant companies have not been established because the primary issues regarding the due diligence done, steps taken for protection of the fund, and most importantly, the reason for investment in a company with no track record and that too with such huge premium was not clarified. Furthermore, the assessing officer noted that due to non-compliance on the part of the assessee, some of the details of the shareholder were not available, and hence the identity of the shareholder is questionable. Full stop. If the identity of the creditors had not been established, consequently the question of establishment of genuineness of the transaction or the creditworthiness of the creditors did not and could not arise. Furthermore, the assessing officer observed that the case has to be judged in the light of preponderance of probability and normal human behavior, and from which it will be easily inferred that the entire transaction lacks substance. Furthermore, on facts, the assessing officer noted that a company that has been recently incorporated without any proven track record does not in any way justify the hefty share premium. Thus, on facts, the assessing officer came to the conclusion that the receipt of share application money is only a facade, FACADE, for conversion of unaccounted money, and the non-appearance of the directors only strengthened this point. Reference was made to the decision in the case of CIT versus Precision Finance Private Limited, 208 ITR 465, and another decision of the learned tribunal in the case of Agarwal Coal Corporation Private Limited versus Assistant CIT 63 DTR 20, and ultimately the assessment was completed, holding that the fresh amount of share application money received along with the premium amounting to rupees 2, 82, 10, 798 remained unexplained and was accordingly added back under section 68 of the Act. The assessee was informed that penalty proceedings under section 271 within bracket 1 within bracket small c will be initiated separately. The assessee carried the matter on appeal before the appellate authority, namely the National Faceless Appeal Center within bracket NFAC. The assessee contended that the addition made by the assessing officer is bad in law, unwanted and unlawful, and the interest charge is also unlawful and not acceptable. The appellate authority took note of the observations of the assessing officer, noted the submissions made by the authorized representative of the assessee, and the grounds canvassed in the written submissions. And thereafter proceeded to take a decision in the matter. The first issue which was considered by the appellate authority was whether the tax recovery officer was an assessing officer. After referring to the various statutory provisions, it was held that the assessee was covered under clause small a of subsection 3 of section 124 of the Act. And apart from that, it was held that not only the tax recovery officer 10/tax recovery officer 4, Kolkata, was fully empowered to pass the order under section 143 of the Act. And the question of the assessee raising the issue of jurisdiction beyond the prescribed time limit does not arise. The next issue which was taken up for consideration is with regard to the correctness of the addition made under section 68 of the Act. The assessee, among other things, contended that the notices under section 133 within bracket 6 of the Act was issued only to 9 out of 30 shareholders. And the details having been furnished, the assessee submitted that they have discharged the burden cast upon them. Furthermore, the assessee submitted that the profit and loss account and the balance sheet containing substantial income was before the assessing officer, and hence the creditworthiness was proved. Certain decisions were also referred to in support of such contention. The appellate authority, in our considered opinion, rightly noted the illegal position that the onus is on the assessee to prove not only the identity of the share applicant, but also the creditworthiness of the share applicant, and last but not the least, the bona fides or genuineness of the share application money credited in his books of accounts. It was held that merely providing proof of identity and other relevant documents is not sufficient, as creditworthiness of the share applicant and the genuineness of the transaction is also important. After noting the decisions of the Honorable Supreme Court, in NRA citation in PCIT versus NRA Capital Iron and Steel Private Limited 2019 412 ITR 161 CIT versus Durga Prasad More 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 1971 82 ITR 540 within bracket SC and Sumati Dayal versus CIT 1995 214 ITR 801 within bracket SC. The appellate authority proceeded to examine the documents in the case of the shares subscriber companies, which are 21 in number. The appellate authority has discussed the factual aspect in respect of each such share subscriber. By way of illustration, if we take up the case of Lucky Prime Financial Consultant Private Limited, the company was shown to be in existence from June 2011 with an authorized share capital of rupees 500,000 and paid up capital of rupees 4,59,600. The subscriber company has collected share premium of rupees 1.76 crores on the share capital of rupees 4,59,600, which was found to be abnormal as the subscriber company had no track record of any activity whatsoever, or there were any projections of any activity, and it had a surplus of only rupees 53,230. Furthermore, the subscriber company had receipts of rupees 5,22,174, on which profit of rupees 44,330 was earned. Full stop. Further, on facts, it was found that the funds collected are entirely invested in loans and advances of rupees 1.06 crores, and there is a bank balance of rupees 88.69 lakhs. Further, the subscriber claimed to have invested rupees 2,50,000 as share application money and premium in the financial year 2011-12. However, there are no investments shown in the balance sheet of Lucky Prime Financial Consultants as on 31/3/2012. Therefore, the appellate authority came to the conclusion that the creditworthiness of the share subscriber remains unproved, and the genuineness of this transaction is also not proved from the documents produced. Similar discussion has been made in respect of all the 21 share subscribers. In paragraph 6.5 of the order passed by the appellate authority, the common features of all the subscriber companies were noted, namely that the registered addresses of some of the companies are common, and the directors of the company were also found to be a group of persons. The accounts of the company were audited by the same group of auditors. There are no activities apparent from the profit and loss provided except for receipt of interest, and all companies have only furniture and computer as assets. There are no vehicles or office premises in the schedule of assets. Thus, on noting all the facts, the appellate authority held that the assessee has not discharged the owners under Section 68 of the Act. Furthermore, more importantly, the appellate authority noted that the first two entities are individuals and they are promoters of the assessee company, and the shares issued to them are not at a premium. Therefore, not therefore. This peculiar aspect was noted and it was pointed out that the promoters do not share the view of the other companies who have subscribed to the shares at premium, about the prospects of the assessee company. Moreover, the assessee company has not provided any documentary evidence for creditworthiness of the promoters, namely Aditya Mundra, Mundra, and Sonali Mundra, MUN, sir, not MUNDHRA. It was found that the remaining 28 companies have contributed rupees 2.77 crores towards share capital at par along with share premium. And the creditworthiness and genuineness of the transactions were not proved. Accordingly, the appeal was accordingly addition of rupees 2,82,00,000,000 was confirmed and the addition of rupees 10,798 was deleted. The assessee carried the matter on appeal to the tribunal, which has allowed the assessee's appeal by the impugned order. Surprisingly, the learned tribunal has not discussed any of the discussed or dealt with the correctness of the finding recorded by the appellate authority, which in our view was a very detailed, which in our view was done after a detailed factual exercise. The learned tribunal has stated in paragraph 17 of the impugned order that on perusal of the paper book and document, the three factors have been proved by the assessee. This, in our view, is wholly inadequate and insufficient for the tribunal to affirm the order or to set aside the order passed by the by the appellate authority. In other words, the tribunal was required to examine the correctness of the factual findings recorded by the appellate authority and then record its views as to why it is not in agreement with the findings of the appellate authority. On reading of the impugned order, it is seen that this aspect of the matter is conspicuously absent. At this juncture, it will be relevant to take note of the decision of this court in Balgopal Merchants Private Limited versus Principal Commission of Income Tax 2024-162 taxman.com 465 within bracket Calcutta. The said decision also arose under section 68 of the Act, and the facts and circumstances were more or less identical. In the said case also, the appellate authority on examining the facts found that the assessee company therein had no track record or asset base for demanding astronomical high premium per share, which defied all commercial and financial prudence and logic. Furthermore, the test of human probability was also applied, and when done so, it was held on fact. It was held that that the high premium, share premium, defies logic. Thus, if the test of human probability is applied to the facts and circumstances of the case on hand, it should have been established by the SSC as to why and for what reason the share subscriber invested in shares of the SSC company at such huge premium, despite the factual position being that the SSC company had no track record. Thus, we are of the view that the learned tribunal did not go into all these aspects and merely proceeded to accept the case of the SSC solely by making certain observation with regard to the paper book which was filed by the SSC. The tribunal, while overturning the order passed by the appellate authority, was required to examine the correctness of the findings recorded by the appellate authority and then come to the conclusion why such findings are not acceptable, and while doing so, reasons have to be recorded in writing. In the absence of all these essential requirements, we have no station to hold that the impugned order is not sustainable in law, and the learned tribunal committed an error of law in allowing the SSC subject. For the above reasons, the appeal filed by the revenue is allowed, and the substantial questions of law are answered in full.
My lord, there was another issue before the tribunal. This assessment was completed by TRO, who cannot be termed as assessing officer.
That objection was raised beyond statutory time.
Deeply obliged.
Next.
Obliged, my lord.
My lord, it may be sent back to the tribunal to consider that issue which has been left open.
Yeah, such in ones.
Yes, no? Against, no?
Obliged, my lord.
My lord, this para 22, they say this TRO issue is left open because the TRO has completed the assessment. He is not a assessing officer in the entire hierarchy. So that issue was taken up before the tribunal.
The decision of appellate authority on that aspect is correct.
On that aspect alone.
Next.
So I'll move a petition before the tribunal for considering this.
You do whatever.
My lord, this has been left open. This is mentioned by the tribunal.
Next.
No.7.
May it please your lordship.
This is the affidavit of service.
There is no delay in this appeal.
Last matter also there is no delay. 2 matters, no delay.
This appeared to be rare, but there was no delay. But here, the
notice served.
Yes, my lord, affidavit service is there, and in the tribunal also, my lord, Mr. Surana, perhaps.
Sir, Mr. Sunil Surana appeared.
My lord, we have not received the memo of appeal yet.
What is the endorsement? What is the endorsement?
My lord,
on what date it was served?
My lord, the item delivered on 31st January 2025.
And as far as I remember,
We may, my lord, if your lordship direct, my lord, serve a copy to my learned senior friend. If my lord and senior friend appears in this matter.
They say it's covered by Hotel Blue Moon.
No, I shall, my lord, indicate what was the issues, my lord. This is
already you served paper on.
As your lordship.
I think this should be below the.
No, this covers under the exceptional clause because this is, my lord, SSC was found to be, my lord, accommodating, my lord, the accommodation entry. That is the reason, my lord, for which, my lord, the assessment was reopened. No, I'll demonstrate
allegation or no allegation.
I will demonstrate that because, my lord, it is a reopening of the assessment, my lord, and on the basis of which, my lord, the
tax effect is 32 lakhs.
Yes.
And you say it falls under exception clause 3.1H. What is 3.1H?
That is, my lord, the exception clause. That is, my lord, the notifications.
He is with the brief.
No, they are
the very interesting point, my lord, may crop up in this matter because this is a jurisdictional objection that has been, my lord, finally, my lord, appeared to have been dealt with by the tribunal. Now, my lord, there are 3 stages of the proceeding where, my lord, the SSC has never raised that issue.
3.1H. Cases involved organized tax evasion, including cases of bogus capital law, gain loss through penny stock, and cases of accommodation entry.
My lord.
And your case is
accommodation entry, my lord. That is the ground on which, my lord, this addition was made in the process of reassessment. So I shall, my lord, serve a copy to my learned friend, my lord. Come back.
All right. We have heard so and so. Mr. S.M. Surana accepts notice for the respondent assessee. Learned counsel for the appellant is directed to serve copy of the appeal memorandum along with annexes. This circular you written. Circular you written. He'll have it.
I'm extremely grateful, my lord.
Number 8.
My lord, I am appearing for the appellant. My lord, I am praying for not today. My senior is engaged in code number 11, my lord.
Who will appear for the notice has been served on the department?
Yes, I have served. May I file the affidavit of service, ma'am?
Who will appear for the department? Customs. All right. Affidavit of service taken on record. None appears for the respondent. Next week.
Number 14.
9.
Number 9.
Lord, 9 I appear for the appellant, my lord. Mr. Arijit Bardhan is leading me, my lord. He has not come for his personal difficulty. I am praying for a not today, my lord. My lord, may it retain its position on the Wednesday.
Will go as 199. From 9 it will go as 199. Not today.
Number 10.
For the respondent. My lord, your lordship had got the occasion, my lord, to deal with this assessee in a penny stocks batch matter. Wherein, my lord, your lordship had held that the addition made on the basis of, my lord, the accommodation entry was proper. Now, my lord, thereafter, a separate proceeding for penalty proceeding has been initiated. Now, my lord, the subject matter of this appeal before your lordship is the penalty proceeding. Now, my lord, I'm, my lord, placing certain portions. First of all, my lord, if your lordship kindly turn to page 11 of your lordship's brief, wherein, my lord, these assessee features in the batch matter wherein your lordship had decided that issue against the assessee and your lordship had confirmed the addition. Following, my lord, the Swati Bajaj matter. Your lordship would find it at page 12 of your lordship's brief. Ram Avtar Dood, that is, my lord, the name of the assessee before your lordship today.
Poor fellow, sir. Individual assessee. Wow.
Yes. Now, my lord, the penalty proceeding has been initiated, and my lord, that has been confirmed by, my lord, the CIT appeal. Thereafter, my lord,
Like 61,000.
Yes.
Where they see all these people we held are all name lenders, because the entry operators and certain other people were collecting these names, and they will pay probably 5,000 rupees to them. They'll collect the PAN details, etc., make them directors of XX company or something, or start investing in the name. All they have to do is give their KYC details. They will open the bank account. These fellows themselves will sign. We have seen that.
No, your lordship have actually observed that portion in that judgment, my lord, which is, my lord, being relied upon. In Swati Bajaj. But the question is whether, my lord, in view of the proceeding that has been initiated against the assessee, whether that is on the basis of a preponderance of probabilities, or whether it is also a question, my lord, if I could, my lord, most humbly indicate, the tribunal, my lord, have dealt with that issue in a matter as if the tribunal is sitting over the court of appeal before your lord, above your lordship.
The tribunal rightly took note of the legal position that assessment and penalty proceedings are distinct.
Separate.
So a man who may be assessed to tax or an addition who might have been confirmed need not necessarily suffer penalty. He can still contest the penalty.
Yes, because since that is a distinctively separate proceeding. But, my lord, that proceeding
tax
is
effect.
now that proceeding, whether may I only indicate this, whether that proceeding, my lord, is required to be independently, my lord, substantiable on the issue that there is any culpability is required. Now, my lord, the tribunal, my lord, had gone on to hold that since there is no culpability, these are not maintainable.
No, stricter proof is required. No?
Stricter proof is required, but, my lord, if I, my lord, only refer to, my lord, the wordings of the tribunal, that is causing, my lord, some difficulties. If your lordship kindly turn to
We'll
page.
clarify that. We'll say the tribunal cannot at any extent vary the judgment rendered by this court,
Yes.
confirming the addition. But so therefore, we are not very happy with the observations. But nevertheless, because the legal position is this, and nothing was brought on record to show that there was
My lord, may I suggest one thing, my lord?
Now, my lord, while dealing with this issue, my lord, tribunal has, my lord, gone on to hold certain principles which, my lord, would inevitably, my lord, admitting the fact that there is a.
My lord, the difficulty is, my lord, the petitioner got the brief, but I didn't get the brief yet. That's it.
You want copy? Yeah, I can.
ঠিক আছে, that will be খারাপ হয়ে যাবে এখন।
where is the show cause notice under 271(1)(c)?
Show cause notice.
It's not an.
That has not been made a part of the stay petition. My lord.
All right, you give him one copy.
I'm giving.
And next hearing, you bring the copy of the show
Yes,
cause.
yes. My endeavor before lordship would be to indicate, my lord, that these proceedings, this penalty proceeding culpability, my lord, that has been independently dealt with.
There will be a batch of cases on this.
And my lord, Supreme Court, larger bench have got the occasion, my lord, to deal.
100% you cannot recover. Assessee will never be able to be located. 100%.
That's the thing.
In this case, my lord, the postal cover has returned with the remark left.
Assessee left.
Thereafter, I sent an email. That's why.
Because the email is see, the address is given. There is no assessee. The email is with the entry operator.
Yes, yes. Assessee is virtually traceable, physically not traceable, my lord.
So
That's the
the
thing.
entry operator became cautious, so engaged the advocate.
My lord, may I suggest one thing, my lord? Since it's the individual assessing, but what is my understanding of the law, this is a civil liability. So there is no question of culpability. Larger bench of Supreme Court, Honorable Supreme Court has held that the civil liability.
You bring some judgments.
Yes, yes. We are on this. We are on this. We'll address that issue.
My lord, please, yes, my lord may confirm the order of the tribunal, but do not decide any substantial question of law. Otherwise, my lord, by citing this judgment.
No, what we have to say is this culpability, whatever observation in the last paragraph.
Yes, paragraph 6 of
has
the.
to be tested.
Yes, that is required to be, my lord, strictly interpreted because that is not the right propositions of law. Because culpability, my lord, has been dealt with in a separate chapter.
We will say that the impugned order gives an impression as if the learned tribunal is sitting on appeal over the decision.
Yes. That is my impression.
Therefore, to that extent, the finding of the tribunal is
has to be go down.
Apart from that, the tribunal has said that a stricter yardstick of culpability is required to be established, for which no reasons have been given.
Yes.
And what is the judgment you are carrying?
That is, my lord, one of
2008 Supreme Court, my lord.
I'm giving this. There are two judgments.
Deleting the penalty will come.
This is, my lord, the latest one.
Dharmendra.
Yes, my lord. This is a larger bench judgment, my lord. Paragraph, my lord. 18, 15, 18, and 19. These are the three relevant paragraphs.
You first come to para 2. That's where the question. Third line, just above placetum F. The question which arises for determination all these appeals, whether 11AC inserted by Finance Act with an intention of imposing mandatory penalty on the persons who evaded payment of tax should be read to contain mens rea as an essential ingredient, whether there is a scope for levying penalty below the prescribed minimum.
I'm kidding. volume 13.
Then you come to same thing just below placetum G. The assessee, on the other hand, referred to section 271(1)(c) of the Income Tax Act, taking the stand that 11AC of the Act is identically worded, and in a given case, it was open to the assessing officer not to impose any penalty. Now you come to the finding.
Paragraph 18 and 19, my lord.
You come to para 9. Contention of the assessee.
Assessee, my lord.
Just below, above placetum C. It is pointed out that section 11A relates to expression assessee shall be liable, and therefore there is discretion to reduce the penalty. With reference to 1C and 1B, it is pointed out that the case of the former, it is liable, while in the later, it shall pay.
Shall pay.
Then, where is finding?
আমরা যেটা দেখবো তার আগে প্রথম থেকে পড়তে পড়তে আসছেন ইচ্ছে করে পড়ছে যদি
Page 387 of the report.
Yes.
Extracted para 33. This court in a catena of decision has held that mens rea is not an essential element for imposing penalty for breach of a civil obligation. They referred to Ferra case.
I'm responding. Then my lord, conclusion starts from paragraph number 15. Court is taking this.
Then you come to page 389, extracted judgment Gujarat Travancore Agency. Last from placetum F. In the case of proceedings under 271(1)(a), however, it seems the intention of the legislature to emphasize the fact of loss of revenue and to provide a remedy for such loss. Although no doubt an element of coercion is present in the penalty.
Yes,
in this connection, the terms on which penalty falls to be measured is significant. Unless there is something in the language of the statute indicating the need to establish the element of mens rea, it is generally sufficient to prove that a default in complying with the statute has occurred.
Yes.
In our opinion, there is nothing in 271(1)(a) which requires that mens rea must be proved before penalty can be levied under that provision.
That's the thing. That's our contention.
Considered, my lord. Thereafter, the finding conclusion.
Where is the finding?
Paragraph 18 and 19. My lord.
Starts from my lord paragraph number 15, goes on to my lord 18 and 19.
So what we will do is, we will set aside that finding of the tribunal.
Yes,
and then we'll say, considering the quantum of penalty to be low, and the assessee being individual, we are not inclined to interfere with that portion of the order passed by the tribunal, setting aside the penalty.
As your lordship said. I shall be, my lord, also indicating another judgment which was, my lord, prior to this one, and that judgment has been, my lord, dealt with by this one. This is a larger one, of course, which your lordship is looking at. Yes. And that SEBI judgment is there, my lord, that has also categorically, my lord, laid down the same
Paragraph
principle.
in SEBI?
I'm indicating that. It is of my lord paragraph number 35 and 36 of the SEBI judgment.
Here it said once it is there, it is automatic.
Yes,
On civil liability, my lord.
civil liability. And my lord, even my lord, if I could my lord put it like this, in the arrangement of the section in the Income
A
Tax Act
breach of
itself,
civil obligation which attracts penalty in the nature of fine, and the regulation would immediately attract the levy of irrespective of the fact whether contravention must be made by the defaulter with guilty intention or not. Unless the language of the statute indicates the need to establish the presence of mens rea, it is wholly unnecessary to ascertain whether such violation was intentional or not on a careful perusal of so and so and so. In fact, this has been noted in this.
yes, it has been taken care of, my lord, by this judgment.
Relied upon on that judgment, SEBI judgment, my lord. And there is another judgment, Dilip Saraf, my lord, which has
That has been
a different
distinguished.
view. That
Distinguished.
has been distinguished with this.
And held.
And my lord,
My lord, I shall my lord only indicate one thing, my lord. Even my lord, even if we do not see to this judgment, my lord, the arrangement of the sections of the act itself, my lord, specified that the question of penalty and impositions of the penalty would only come into the second chapter, not on the chapter of 271. I shall my lord indicate that to your lordship, because the statute and the language of the statute was very clear on that when culpability is to be seen into. So 271 1C proceeding is not the proceeding where, my lord, the culpability of the assessee can be looked into.
that is under culpability is under chapter 22, my lord. Section 278C. 278E.
278E, my lord, falls under that chapter, my lord, wherein, my lord, the culpability has to be seen.
That is for regarding prosecution and offences.
Act. Sorry, sir, not for me. Page 1161. Which provision you are referring to?
278E.
278E.
That is under chapter 22, my lord, for offences and punishments.
ছোট না, দেখতে অসুবিধা হচ্ছে। তুমি
Presumption as to culpable mental state.
Yes.
So this is under the chapter prosecution.
prosecution and offenses, offenses and prosecution.
Chapter 22,
my lord.
prosecution and offenses and prosecution.
Yes. So it has to fall under the category of offense to my lord involve culpability, mens rea.
And the penalty. And penalty is imposed under section 271C. That is under chapter 21. Imposition of penalties.
Sir, please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated August 29, 2024, passed by the Income Tax Appellate Tribunal B Bench, Kolkata, in ITA number 91/KOL/2024 for the assessment year 2015-16.
না না ভালো করেছো তুমি এটা ভালো করেছো তো স্বামী এসে পাবে না তোমার সাথে অ্যাটলিস্ট আমার এরকম ব্যাপার হ্যাঁ হ্যাঁ
The revenue has raised the following substantial questions of law for consideration. Page 6 sir, and 7, 1, 2, 3, 4. We have heard so and so. The undisputed fact is that the addition made by the assessing officer on the assessee under section 68 of the Act was affirmed by this court. The batch of cases were affirmed by this court by judgment dated 8/7/2022 in a batch of cases reported cases, namely PCIT versus Swati Bajaj and others, 2022 SCC Online, Calcutta 1572. The present proceedings arise out of penalty proceedings initiated under section 271 within bracket 1 within bracket C of the Act to the tune of rupees 4,61,771. The learned tribunal in the impugned order noted that the addition made by the assessing officer on the ground of bogus long-term on the ground of a bogus claim of long-term capital gains was affirmed by this court, observed that the penalty proceedings being a different proceedings than the matter concerning quantum addition during the assessment proceedings, the penal provisions of levy of penalty under section 271 within bracket 1 within bracket C, the stricter yardstick of culpability is required to be established. After making such an observation, the learned tribunal proceeded to hold that considering the overall facts and circumstances of the case, and also considering that the assessee had claimed a small amount of long-term capital gain, and that the possibility that the assessee might be a bona fide beneficiary of a long-term capital gain cannot be ruled out, gave the benefit of doubt to the assessee and deleted the penalty. The learned senior standing counsel appearing for the revenue pointed out that certain observations made by the learned tribunal in paragraph 6 seeks to give an impression as if the learned tribunal was sitting in appeal over the decision in the case of Swati Bajaj. Though we also had such an impression on going through paragraph 6 of the impugned order, all that is required to be clarified is that the learned tribunal cannot do so in a proceedings which has come upon appeal before it, which arise out of a penalty proceedings under section 271(1)(c). Therefore, even if it is even if the revenues of the opinion that the observations gives such a impression, it needs to be clarified that the tribunal cannot, the learned tribunal cannot do so, and such impression need not be drawn from the observations made in paragraph 6 of the impugned order. The learned tribunal, while granting relief to the assessee, made an observation that for levying penalty under section 271 1C of the Act, stricter yard of culpability is required to be established. This finding, in our view, is not legally sustainable. We support our conclusion by placing reliance on the decision of the Honorable Supreme Court in Union of India and others versus Dharmendra Textile Processors 2008 13 SEC 369. The question which fell for consideration before the larger bench in a batch of appeals was whether section 11 capital A capital C of the Central Excise Act 1944 with the intention of imposing mandatory penalty on the persons who evaded payment of tax should be read to contain mens rea as an essential ingredient, and whether there is scope for levying penalty below the prescribed minimum. The assessee in the said case referred to section 271 within bracket 1 within bracket C of the Income Tax Act and took a stand that section 11 capital A capital C of the Central Excise Act is identically worded, and in a given case it was open to the assessing officer not to impose penalty. The Honorable Supreme Court had taken note of the statutory provision, namely section 271 1 within bracket small c and section 271 capital C, referred to the decision in Chairman, SEBI versus Sriram Mutual Fund 2006 5 SEC 361. Took note of the decisions. Notice a plural. Directorate of Enforcement versus MCTM Corporation Private Limited 1996 2 SEC 471. Gujarat Travancore Agency versus CIT 1989 3 SEC 52. And held that the explanations appended to section 271 within bracket 1 within bracket C of the Income Tax Act entirely indicates the element of strict liability on the assessee for concealment or for giving inaccurate particulars while filing return. It was further held that the decision that the judgment in Dilip N. Shroff versus CIT 2007 6 SEC 329 has not considered the effect and relevance of section 276 capital C of the Income Tax Act. It was further pointed out that the object behind enactment of section 271 1 within bracket small c read with explanations indicate that the said section has been enacted to provide for a remedy for loss of revenue. Full stop. The penalty under the provision is a civil liability, and willful concealment is not an essential ingredient for attracting civil liability, as in the case in the matter of prosecution under section 276 capital C of the Income Tax Act. Accordingly, it was held that the decision in Dilip Shroff's case was not correctly decided, but SEBI's case, SEBI case, has analyzed the legal position in the correct perspective. In the light of the larger bench, in the light of the decision in Dharmendra textile processes, the observations made by the learned tribunal, which appears to suggest that the culpability has to be established, does not lay down the correct legal principle. In other words, the tribunal cannot hold that mens rea is an essential ingredient cannot sorry, what did I say, sir? Cannot hold that willful concealment / culpability is required to be established, which is not required to be done, as the same is a civil liability, as explained by in Dharmendra textile processes. Therefore, we are inclined to set aside that portion of the order passed by the learned tribunal while interpreting the provisions of section 271 within bracket 1 within bracket small c of the Act, as it is not in consonance with the decision of the Honorable Supreme Court in Dharmendra textile process. With regard to the penalty which has been imposed on the assessee, considering the penalty is less than rupees 5 lakhs and the assessee being an individual, we do not propose to interfere with the relief granted by the tribunal to the assessee by deleting the penalty. Therefore, to that extent, the order is affirmed. Accordingly, the appeal is partly allowed and the substantial questions of law are answered in favor of the revenue.
My lord, if my lord may please also to observe that one of the arrangement of the section, that is the third limb of my submission, that suggests that this mens rea portion is not.
No, that one more paragraph, sir, before the last one. As rightly pointed out by the learned senior standing counsels appearing for the revenue, the various provisions of the Act which fall in chapter 22, Roman 22 of the Income Tax Act, stand in a different pedestal, as the said chapter deals with offences and prosecutions, where offences and prosecution. By way of illustration, if we refer to section 278 capital E, in the said in such offences, the prosecution is required offense in offense under the said provision, it requires a culpable mental state on the part of the accused. Whereas section 271 1C falls in chapter 21.
21.
Which deals with penalties imposable. This is one more distinction which has been drawn in the Act itself, which is of utmost relevance.
I'm extremely grateful.
Stop with this. Everybody is very, very relaxed and
I'm grateful, my lord.
What is this, Smita? Your matter? Huh?
No, my lord. I'm opposing this application. Your lordship clearly comes to page 14. This is the question of law, my lord, paragraph 24. Kindly see the conduct of the SSC, my lord. Not appear before the lower authorities. Now they are coming up before the tribunal. Now they wants the recalling of that order, that an ex parte order has been passed. Subsequently, a miscellaneous application has been filed. And if your lordship kindly takes up the miscellaneous application, my lord, everything has been categorically dealt with.
This was sir.
May I beseech your lordship to kindly have a look at paragraph 3 of the tribunal's order, which is appearing at page 48 of the stay application. Your lordship, in paragraph 3, the tribunal has held that in response to the notice of hearing in this miscellaneous application, no one has come present. It is pertinent to note that assessment order was passed according to the best judgment of the assessing officer. The SSC did not appear. The SSC did not prosecute its appeal before the learned CIT appeals. It has been decided ex parte. Next, your lordship, it has given its email ID. It has given a mobile number also. The efforts were made to serve notice in all these three modes. The copy of the notice issued through RPAD is available on record, which postal authority has reported as closed. The bench clerk during the course of hearing of the appeal has issued notice through email as well as also RPAD. Next page, your lordship, every efforts were made by the ITAT to serve the notice. The SSC has not challenged in the miscellaneous application that this address was incorrect address. It has also made a bold statement that the notice was not served without submitting any affidavit of directors or any corroborative circumstance leading to alleged non-service of notice. By the past history of the SSC, we are satisfied that it is only making vague statement. We have already observed that neither before the learned assessing officer nor before the learned CIT appeals, it has prosecuted its proceeding. It has neither appeared before the tribunal when its appeal was listed, nor it has appeared before the miscellaneous application. It suggests that for the purpose of completeness of the record, it is just filing application before the higher forums. Now, your lordship, I would like to controvert this observation of the tribunal mainly on 4 grounds. Firstly, your lordship, the proceedings, the case details regarding this miscellaneous application is appearing at page 53 to 58 of the stay application. If your lordship would kindly take page 53 onwards. From page 54 onwards, the details of the case is given. In most of the occasions, as your lordship would peruse the records, that the authorized representative of the SSC, Sunil Surana, has been present on most of the occasions, in every occasion, in fact. And the only reason that the case has not been taken up either was because of unavailability of the forum or any other reason, but the SSC...
did the SSC appear before the CIT appeals?
No.
Yes, your
Not
lordship.
before the
Yes,
assessing
that is my
officer
second
also.
point of contention, your lordship. Firstly, the SSC has appeared before the tribunal in this miscellaneous application. It is evident. Second is, your lordship, at page number 32, which is the order of the CIT appeals, the order records at the very, in serial number 9, present for the appellant, Mr. Praveen Kumar, FCA, authorized representative. Your lordship would also peruse page number 34, Mr. Praveen, paragraph number 5. Mr. Praveen Kumar, FCA, appeared on behalf of the SSC and made submissions. So the observation of the tribunal is wrong because the SSC has appeared before the CIT appeals. It has appeared before the tribunal in the miscellaneous application. Third of all, Your Lordship, if Your Lordship would kindly have a look at page number 51, where we had made an application before the tribunal for obtaining a certified copy of this miscellaneous application. We had also asked the tribunal to provide us with the evidence of non-service of notice of hearing and any evidence of emails sent and any proof of service. We have only received a copy of the certified copy of the tribunal's order. Nothing else has been given to us, Your Lordship, as proof of service of the hearing notices. And most importantly, Your Lordship, at page 42, the tribunal's order that we had challenged, over there also, Your Lordship, no notice was served to our address. The date of hearing was 14 December and the date of pronouncement was 15 December. No opportunity of hearing was given to us, Your Lordship.
Oh, this miscellaneous application 6 of
Yes, Your Lordship.
2023. What was the prayer in that application?
To Your Lordship, the earlier application that we filed before the tribunal, which is at page 42,
No,
we
where is
restored that.
where is the first order passed by the tribunal?
42, Your Lordship.
Not clear. So you filed a miscellaneous petition.
To restore this application.
45. Your case was non-service of notice.
Yes, Your Lordship.
Notice of hearing. On 14/12.
Yes, Your Lordship.
No, according
date
to
of hearing.
14/12, notice was not served.
Yes, Your Lordship.
Then you filed this miscellaneous application after you had obtained the certified copy pursuant to your application in 51.
Yes, Your Lordship.
So you received the order in MA6. No. You're asking for, that is after MA6 was dismissed.
We have obtained a certified copy of the order.
All right. Now, according to you, you filed the application MA6 to recall the earlier order.
Yes, Your Lordship.
Saying that non-appearance is due to some sufficient cause. In that application, no notice was served.
No notice was served, Your Lordship. And only one date of hearing was given, which we
And
were
your
not advised of.
counsel entered appearance. Your advocate has entered appearance.
No, Your Lordship. No one appeared on behalf. We were
So you
not
said
Enter appearance.
so-and-so is appearing.
in the
right?
miscellaneous application.
No.
Also, when this miscellaneous application was heard, the authorized representative has appeared before the tribunal on many occasions. The case was, however, adjourned
That is MA6.
in MA6.
But on the last date, nobody was there.
Your Lordship, on the last date, we were not there. We were not apprised of the date of hearing, Your Lordship. Because on earlier many occasions, the authorized representative of the SSC had appeared. However, the bench was not functioning.
No. Page 58, you come to page 58.
Yes, Your Lordship.
It says case is fixed for hearing.
On 30th June. Next, Your Lordship.
But on 21st June itself, hearing concluded. Page 59, you see.
21st June 2024, and this is
sorry.
30th June 2023.
Then what happened after 30th
Your
June?
Lordship, at page 57, actually the case
this
status
way,
goes
so-
back.
okay.
Yes, Your Lordship.
June, then adjourned. September, then 22nd September, adjourned.
In all these dates, the SSC was
At whose
represented.
instance it was adjourned? But yes, Mr. Surana has appeared.
Yes, Your Lordship.
Then adjourned to 6th October, adjourned to 8th October. As bench did not function on 16/12, hearing to 23rd February. Bench did not function 1st March. Adjourned to both parties informed. 26/4. Non-availability of Honorable so-and-so Girish Agarwal adjourned to 21/6. Inform parties. So from April, it was adjourned to June. And no,
Either they have not appeared or the bench was not sitting or they have sought for an adjournment.
no. See, the adjourned date was 21/6/2024. But on that day, the case was not listed.
Your Lordship.
It was listed only on 23rd August. Correct?
Yes, Your Lordship. At
See, you should have prepared a dates and events. You should have prepared a dates and events to demonstrate this.
Your Lordship, it has been demonstrated at page number
You should have referred to that while you make submission. Page 10.
page 10 of the say
That's
application.
how you start.
I tender my unconditional apology, Your Lordship.
So up to 26/4/2024, your assessee was represented before the tribunal.
Yes, Your Lordship.
But on 26/4, what happened? It was adjourned to 21/6. Correct?
Yes, Your Lordship.
What happened on 21/6?
The order was passed when
No, order was passed
Hearing concluded.
yeah, the hearing
in
was
August.
concluded.
Pronounced on 23rd of August.
Hearing
but the
concluded?
hearing got concluded 21st June, my lord. That was the last date of hearing.
24. Oh, on that date, not a case of supine indifference, no. But when we send it back to the tribunal, it will be a big embarrassment for them, saying that this, that,
Yes,
this,
ma'am.
that.
It's not the case.
But
that they were not given any opportunity, but they have not availed that
no,
opportunity.
they
my
were
lord.
represented by Mr. Surana.
It's only before the CITA, my lord.
No, this is tribunal's dates.
Tribunals, because but the dates got adjourned, my lord. Time to time because of the various reasons.
But before CIT appeals, you could not establish your.
But the order itself records it that we
You
will
appeared. No, there is no problem.
made our
But
submissions.
on the factual aspect, you are not able to. No, madam. Page 20, you come. Page 20.
Page 20.
Para 3.2. However, during the assessment proceeding, nobody on behalf of the assay appears before the undersigned till the date of passing this order.
Yes, Your Lordship, the allegation actually pertained to unexplained crash credit under Section 68. So the directors were issued summons, but they could not comply with the same.
Oh, it is
So
not the.
this is the assessment order,
Not
Your
the.
Lordship. Before the CIT appeals, the SSE was represented.
If your lordship kindly comes to page 19, 2.2, the penultimate paragraph, that they, as stated above in this case, no compliance was made on behalf of the SSC on the dates of hearing, and even till date, it is evident from the course of action that notice under section 100, fixation of the letter, Ashoka's notice, along with the summons were issued and served by the postal authority on the director of the SSC, Mr. Basant Agarwal. Even after that, no compliance was made by the SSC.
The fact remains, Your Lordship, that the tribunal has erroneously recorded that we have not been represented before the CIT appeals,
That
which
is
is
wrong.
as well as in the miscellaneous application 6 of 2023.
But the CIT appeals, Smita, if you see the order,
Yes, ma'am.
it says I have gone through the order of the AO. Then para 8, page 34, NRA IN. Then NR portfolio, page 35, Nova promoters, Nipun builders, Rajmandir Estates, Nova Promoters, Hindustan Tea. Conclusion, it is crystal clear. What is crystal clear? Nothing is clear.
Paragraph 13, my lord. The observation of the
This is all available in the system.
And they wanted to adduce the
paste.
additional evidence also, my lord. They wanted to adduce the additional
Send it back to the AO.
Send it back to the AO. Because they also did not represent before the assessing officer. So they need to.
This appeal by the SSC under section 260 capital A of the Income Tax Act 1961 within bracket, is directed against the order dated August 23, 2024, passed by the Income Tax Appellate Tribunal C Bench, Calcutta, within bracket tribunal in MA number 6/KOL/2023 in arising out of ITA number 1529/KOL/2019 relative, not relating, for the assessment year 2012-13. The assessee has raised the following substantial questions of law for consideration. Where are the questions, madam?
Page 14, your lordship.
A, B, C, D not required, sir. Heard so and so, so and so. The appellant assessee had filed a miscellaneous application before the learned tribunal in MA number 6/KOL/2023. Filed miscellaneous application number 6/KOL/2023 to recall the order passed by the tribunal. The ex parte order passed by the learned tribunal dated 15/12/2022 in ITA number 1529/KOL/2019. The learned tribunal held that at the time when the miscellaneous application was heard, none was present on behalf of the assessee, and that the assessee also did not participate in the assessment proceedings, resulting in a best of judgment assessment, and that the assessee did not prosecute its appeal before the Commission of Income Tax within bracket appeal CIT, which was decided ex parte. With this reasoning, the learned tribunal dismissed the miscellaneous application. Agreed by such order, the assessee has preferred the present appeal. After we have elaborately heard the learned advocate appearing for the appellant, assessee, as well as the learned senior standing counsels for the respondent department, we find that the learned tribunal had committed a factual mistake in holding that the assessee did not appear before CITA. The fact remains that the assessee had appeared before the appellate authority and contested the proceedings on merits. With regard to the prayer made in MA 6/KOL/2023 was to set aside the order passed by the tribunal dated 15/12/2022, by which the tribunal dismissed the assessee's appeal since the assessee was not represented. What is required to be seen is that whether the conduct of the assessee was so bad that the assessee would not be entitled for any discretionary remedy. We note that when the appeal was the appeal was filed before the tribunal during the year 2023. 13/6/2023 was the first date of hearing fixed for the appeal, and the assessee was represented. Subsequently, the case was adjourned to 21 7/2023. However, the assessee was not represented. The case was further adjourned to 1/9/2023, the assessee was represented, and subsequently on 22/9/2023, the case was adjourned since the bench of the learned tribunal was not functioning. Subsequently, the case was listed on 6/10/2023 and adjourned at the request of the assessee's authorized representative. On 16/12/2024, the bench of the learned tribunal did not function and the hearing was adjourned. Similar was the reason for adjournment on 23/2/2024 and 1/3/2024. On 22/3/2024, the case was adjourned and fixed for hearing on 26/4/2024. On 26/4/2024, on account of non-availability of an honorable member of the tribunal, the case was adjourned. And it appears to have been listed on August 23, 2024, on which date the miscellaneous application was dismissed. Correct?
Lordship, the date would be 21st June 2024.
Hearing concluded, order was.
Hearing
Sorry.
was next.
Case was adjourned to 21st June 2024, and the same was dismissed, and the application was dismissed on account of non-appearance of the assessee. The chain of events clearly show that the assessee had been diligently prosecuting the matter and cannot be held to have slept over their rights. As already noted, the assessee had appeared before the CIT appeals. However, the learned tribunal had committed a factual mistake in observing that the assessee did not appear before the appellate authority. We have gone through the order passed by the appellate authority, and we find that the appellate authority has not discussed any facts, nor dealt with the grounds which have been raised by the assessee, though the grounds have been extracted in the order passed by the appellate authority in order passed by the appellate authority dated 23/5/2019 in paragraph 2. Thereafter, the appellate authority refers to the various decisions, and ultimately the conclusion is in paragraph 13, holding that the assessee has not proved the 3 ingredients required under section 68 of the Act. We are of the view that there is no discussion on facts, despite the assessee having appeared before the appellate authority. Therefore, we are of the view that the assessee should not be left remediless and should be given an opportunity to put forth their case on merits. Since the assessment proceedings were a best of judgment assessment, we are inclined to remand the matter back to the assessing officer for a fresh consideration. For the above reasons, the order passed by the learned tribunal and the order passed by the appellate authority and the assessment order are set aside, and the assessment is restored to the file of the assessing officer, who shall decide who shall complete the assessment after affording an opportunity of personal hearing to the authorized representative of the assessee. The assessee is not entitled to seek for any adjournment and shall appear before the assessing officer either in person or through the authorized representative on the date and time as fixed by the assessing officer. It is made clear that we have not gone into the merits of the matter, and it will be well open to the assessee to raise all factual and legal grounds before the assessing officer. The appeal is allowed for the above reasons. Consequently, the substantial questions of law are left open.
Since the allegation of the non-service of the notice has been ruled out, my lord, but the thing is this is also incumbent upon the SSCs to be
One
more
hearing
vigilant.
getting one
More
hearing,
vigilant, but mere fact, this was a settled proposition, my lord. They would have been more vigilant.
they have been diligent. You can't say they were.
I'm deeply obliged, Your Lordship. I'm grateful.
You give your names so that we can record it down.
I'm grateful, Your
Must
Lordship.
be her maiden appearance before your lordship.
Oh,
but
is
she
it so?
did it very
No,
well.
Your Lordship, I had the opportunity. I was lucky enough to appear before Your Lordship on the last occasion. as well.
Oh, you had appeared earlier also.
No, it's not your
But
maiden.
this combination, this is the first time.
Yes, Your Lordship.
You have to thank ladyship also. Good.
I'm grateful, Your Lordship.
My lord, item 11, 12 may be
No,
taken.
11 is
I'm sorry, 12 and 13 may be taken up next Friday because nobody is appearing from the revenue side.
Next Friday, Holy.
We are coming, we are coming.
Yes.
First Agarwal is here. What? Holy is
It will be my pleasure, my lord.
whatever you want. If it's next week after.
Week up. Deeply.